Good afternoon. My name is Katherine Nixon. I'm a Senior Vice President in the legal team at the DIFC. I'm joined today by Justina Stewart, a barrister with Outer Temple Chambers. Justina has a focus on commercial litigation and in particular expertise in banking and financial services and fintech and digital assets. She's been described as one of the UK's leading crypto barristers. Justina and Outer Temple Chambers have worked very closely with the DIFC over the last 18 months in shaping and drafting the DIFC's new digital assets law. Justina, thank you for joining us. Hello, how are you?
Good afternoon. I'm very well.
Good. So this is the first digital assets law to be enacted globally. Why is this law needed now?
So why is this law needed now? Well, in a nutshell, digital assets and blockchain applications are huge growth areas. However, there has been a considerable lack of legal certainty in these fields, which we felt was important to address. So digging into this in a little bit more detail, if we take by way of example the banking and financial services ecosystem, we're seeing a massive rate of innovation with key players including financial intermediaries, custodians, hedge funds, brokers, software developers, and so on. Now, on the one hand, we have the cryptocurrencies themselves, simplest example being perhaps Bitcoin. And in that area, we're seeing increased interest in crypto derivatives trading and the taking of security over and leveraging of cryptocurrencies. But there's also huge appetite for digital assets beyond the usual cryptocurrencies. For example, blockchain-based tokens, which represent traditional assets like bonds. However, if the benefits of digital assets and the underlying technology is to be harnessed optimally, what players in this space really want and what they need is legal certainty. So to give a couple of examples, players whose digital assets are held by a custodian, they'll want to know whether they can recover the digital assets if the custodian becomes insolvent. Or would it be the case, for example, that the client's digital assets would form part of the pot to be distributed across all unsecured creditors, which will most likely leave them much worse off? Likewise, let's consider a fraud scenario. Say a thief steals a digital asset and then sells it on to another person, and that person is entirely innocent. Which of the innocent parties should be entitled to the asset? The initial victim or the purchaser of the assets? The key point is that you can't work out the answers to any of these types of questions unless basic principles of property law in relation to digital assets are clear. And the most fundamental question is, how do you establish and transfer title to a digital asset? Then the next set of questions is, how does this apply to particular scenarios, like the taking of security? And then there's a whole range of further questions. For example, smart contracts are increasingly used across a range of industries, but how do you interpret contractual terms in the context of smart contracts? More broadly, what remedies are available to claimants in relation to disputes over digital assets? Globally, there has been real uncertainty on these basic issues. To date, the focus around the world has very much been on the regulatory side, and understandably, but it's not within the regulator's remit to address the underlying property law and other foundational legal issues. Of course, some common law jurisdictions have grappled admirably with some of these issues, but the common law, it develops incrementally and slowly. So, in essence, rather than waiting for what could be a very long time, the DIFC has introduced much needed certainty by way of legislation.
Okay, so the law is in place and it deals with these fundamental property law questions. Can you explain in a bit more detail when the law applies and perhaps provide a bit more detail around how the law is structured?
Yeah, absolutely. Crucial question, of course. The law applies when DIFC laws apply, or the parties have chosen to govern their relationship under DIFC law. So a prime example would be an exchange where digital assets are traded and whose standard terms and conditions are governed by DIFC law, or a financial institution transacting under DIFC law. There are, of course, more complicated examples where a party establishes a nexus to the DIFC to obtain jurisdiction under DIFC law. Moving on to how the digital assets law is structured, what we have in the main body of the law, first of all, we address the foundational property issues. What's a digital asset? How is title to a digital asset established and transferred? And then there are provisions designed to deal specifically with the question of when a person is liable for interfering with the use of another person's digital asset. That's something which has been very topical in the common law world. And then, importantly, in Schedule 2 of the new law, many amendments to various DIFC laws are listed. These amendments, they're relevant to and they're designed to cater for digital assets, although it's important to note that some of the amendments apply beyond digital assets. So that, in a nutshell, is the structure.
Okay, we'll come back to the amendments. But first of all, you mentioned that cryptocurrencies like Bitcoin are one example of a digital asset. But of course, that's just one example. How does the law define what a digital asset is?
So the first point I'd make, the overriding point, is that the definition of a digital asset in the law, it's intended to be tech neutral. Now, essentially, we've come up with three criteria for defining a digital asset as a matter of property law. Firstly, it's data as it exists in terms of an underlying system, namely the blockchain, and its rules. So in other words, it's not just the data itself that exists on the database, but the data as it exists in the context of the underlying network and system rules. Secondly, it's independent of persons and the legal system. So the digital asset exists regardless of whether there's any law in place dealing with the digital asset. And that's to be contrasted, for example, with a debt claim. A debt claim only exists because we have laws that recognise the contractual obligation. And a digital asset is independent of any person. And that's because it's a thing as opposed to a right or a claim. Thirdly, a digital asset has to be rivalrous. That means that if I control the digital asset, then no one else control it or duplicate it. That's to be contrasted with, let's say, a Word document, which I can share with many people, and each person can change that document as they wish. There's another important point, I think, and that's how a digital asset is characterized. The law says, the digital asset law, says that it's intangible property that's neither a thing in possession nor a thing in action. Rather, digital assets fall within a third category of property. And this settles, in the DIFC law context, a debate that has been raging in the common law world for a while about how to characterize digital assets. So basically, once you've established that the asset falls within this definition of digital assets, you can then apply the digital assets law and other relevant DIFC laws to work out your legal rights and your obligations, giving you a lot more confidence about the legal implications of particular transactions.
You've also mentioned that the digital assets law has had an impact on various other laws in the DIFC. Could you tell us a bit more about those changes and why they're necessary?
Okay, well, there are a large number of amendments, but to highlight just a few. The law of security, this was the law that was most significantly updated. It was updated to ensure that, initially, to ensure that security could be taken over digital assets. And, for example, to clarify how priority is established as between different security interests in digital assets. Now, as regards the law of security, this started off as a simple review of the old law, but it resulted in a complete rewrite to modernise the law. The new law, it's very much influenced by the UNCITRAL model law on secured transactions, but it also incorporates a chapter dealing with financial collateral arrangements, which may include digital assets. So this is super important to those operating in the banking and financial services sphere. It's a really positive development for the DIFC, and I think it gives parties a best in standard securities law regime. Other important laws that were updated include contract law that was amended to deal with smart contracts and the unique issues that they throw up. And then importantly, the contract law defines money as anything that performs three essential functions of money. It's a medium of exchange, it's a store of value, and it's a unit of account. And the contract law makes it clear that money includes a digital asset if the digital asset performs these three functions. And we see this concept of money reflected in other laws, for example, the insolvency regulations and the law of damages and remedies. And basically, this means that digital assets are treated in the same way as money under those laws if they satisfy the three functions of money. And that could have potentially wide-ranging consequences in the digital assets scenario. Next law, the personal property law, that's been amended to deal with the question of when an innocent transferee of an asset takes clean title of an asset. So it's super important in, for example, the fraud context. Law of obligations. Significantly, there are provisions now recognising and addressing electronic trade documents, which of course is a very important part of modernising trade finance. Unfair contracts terms law, there are now protective provisions in relation to unfair terms in contracts concerning digital assets. And then there are some other changes, for example, to the trust law, to clarify that a trust over digital assets can be created even where the identities of beneficiaries is unknown. So that's very much a whistle-stop tour of just some of the amendments. I really would recommend, though, taking a look at Schedule 2 of the Digital Assets Law for a complete list of those amendments. We've put them in one place for ease of reference.
Justina, thank you. As you say, this has been a whistle-stop tour, but incredibly informative. I think it'll be very interesting to see how this area of law continues to develop.
Indeed, and thank you, Katherine. It's been an absolutely brilliant project to work on, and I, for one, am very much looking forward to seeing how things develop.
Absolutely.